Welcome back to Open Line tonight. We are talking with two experts on the law. Representative Mark Pody, who is a Republican out of Lebanon, has introduced the Natural Marriage Defense Act here statewide, and also Abby Rubenfeld, an attorney here in the area. Thank you both for being with us tonight. We're talking about your bill that you have introduced. Folks are lined up on the phone. I promise we get to some of the callers. So, Joe, thank you for being with us tonight on Open Line. Go ahead with your question or comment.
Yes, ma'am. The question I had was one of the ladies said that the Supreme Court decision was supreme, but I do believe there's a bunch of experiences where the Supreme Court was either overturned or not heeded, like with the Dred Scott law and with Andrew Jackson, where they actually had a ruling that said that he had the right to put the Cherokees on Trader Tiers, and he said, I don't care, and he did it anyway. And another thing, too, the 10th Amendment to the Constitution, the way I understand it, I might be wrong, but it says that anything not guaranteed in the Constitution of the United States is guaranteed to the states and to the people. And
well, Joe, let's talk about these two things. I think that could be two good things here. So, Abby, let's start with you. Has the Supreme Court ever been overruled, or have they ever had to backtrack on a ruling?
They can't be overruled. They're the Supreme Court. They can change their minds, and that has happened before. Fortunately, the Dred Scott decision was overturned, and the same could be said about their ruling that sodomy laws were okay. It was okay to criminalize private consensual sexual behavior between certain people. That was overturned also. And I suppose at some point later on, the Supreme Court could change their mind on this issue too. I mean, we all know the political beliefs of judges affect how they rule, so that could indeed happen, but it would have to be the Supreme Court overturning itself. And we have I mean, I respect that the voters voted, but that's not always how we determine things in this country. I mean, we have fundamental rights. We have a Bill of Rights. Our system is set up so that the majority can't impose their beliefs on a minority just because they have more votes. I mean, that's just not how we work. So, no, that, you know, respectfully, he's not correct about what can happen with this. A state cannot pass a law saying we're not going to do what the Supreme Court says. It's unconstitutional.
That's what you're calling for, isn't it, though?
I am calling for us to hold strong to what we've already passed. That it's already there. And
let me ask you this. I just want to interrupt. Is this only about gay marriage, or as Abby would say, it's marriage now, marriage of same-sex individuals?
Okay.
Is it just about that?
I'm going to look at two issues, okay? Okay. First, you know, I believe that the marriage issue itself and the ruling, I believe, was incorrect, and I strongly would oppose that, okay, just on religious beliefs alone. But how the Supreme Court did it, I'd be bringing the same law if they were ruling the same way on our Second Amendment or on our First Amendment or whatever amendment, you know, whatever our rights are. I don't believe that they had the right grounds to make this ruling, period. I think that if we look at even what Abraham Lincoln had said in one of his inaugural addresses, you know, he said there's when you're looking at the courts, there's a way to say, is this a law that we should be following or not? And this is Abraham Lincoln. He said, if it's a unanimous decision, if it is something that it's not partisan, and he says if it has the common sense of law, we need to follow it. And Abraham Lincoln said, if it's not, we need to resist it. And in this court ruling, there were 9 judges, and it was basically a tie. You had 4 judges on one side, 4 judges on another side. So this was decided on a split decision as narrowly as we possibly can by one unelected individual that made this decision for the 4 states that it affected. You know, and some people say, well, it affected the whole United States. It didn't. There was only 4 states that were involved in this lawsuit.
Can I respond to that?
Sure.
Because people are entitled to have whatever religious beliefs they want, and I respect that, and I would fight for the right to do that. If there was a law or a ruling that said that a particular church had to do marriages between same-sex couples and the church didn't want to, I would defend their right to resist that, because another fundamental principle in our Constitution is the separation of church and state. People can't impose their religious beliefs through the government on other people. Religion's supposed to be separate. So I don't, the fact that 80% of people are just Representative Pody, that it affects their religious beliefs is extremely important, and we have to respect those religious beliefs. but that's not an argument against civil marriage for same-sex couples. And the other thing I wanted to say is about this argument that it was five lawyers that decided this, only one person. I didn't hear any of these Republicans that are so upset about that jumping up to say it was a 5-4 decision that put George W. Bush in the White House in 2000, or complaining about the Citizens United decision that meant that Republicans can buy presidential elections. Those were all 5-4 cases too. The way our country works is we have a Supreme Court of 9 people. Our founders decided to have that third branch of the government, which is equal to the other two, to have it be appointed officials who are appointed by the president and approved by the Senate. That was how they built the checks and balances. It was very intentionally people who were not elected, so they wouldn't have to worry about this number of people voted this time, this particular election on this particular issue. They're supposed to look at the Constitution and interpret it the best they can. And that's what they did. And I don't like a whole bunch of the decisions of the Supreme Court that are 5-4 or some that are 9-0, but oh well, like you have to go by them. They're the Supreme Court.
Let's get back to the callers. We'll get to more, but let's hear what the folks have to say. David, you're on Open Line. Thank you for holding so tight for us. Go ahead with your comment or question.
Well, I think both the speakers on the show have got valid points. However, I'm holding in my hand a copy of the Anti-Federalist Papers, and as we look at the Constitution, we find that there were people like Patrick Henry and George Mason and others who were afraid of the power of the federal government, and that's the reason why we came up with the Bill of Rights. And in the context of that, Jefferson and others of our founding fathers, they wanted to restrain the federal government, but now it's become fearful. And we see this in the militarization of the police. On the subject of marriage, the Bible plainly teaches that God created man and woman, and that he blessed that. And he also, if we believe the Hebrew Scriptures from our friends at the synagogue, Sodom and Gomorrah was destroyed for practicing homosexuality. So there's a clear ethic in the Scriptures, and that's been practiced, by Bible-believing people since the founding of this country. And I don't understand the moral confusion of that. So I'm just wondering, the Supreme Court, yes, it is a powerful court, but God is more powerful than the Supreme Court, and it has reversed itself because it's filled up with so much humanism now that they don't have a moral compass like they used to have. So that's my thoughts, and both the speakers have got valid points. But I object to sanctioning that which God has put disapproval on by the state. And we saw an individual who had Christians' belief wind up in jail up in Kentucky because she didn't want to become a part of that because it violated her conscience. So I feel like there should be a way that Christians are able to participate in the state and have their influence in it as salt and light. But I feel like we're losing our moral compass here because the fundamental foundation or institution that God ordained or that holds society together is the family.
Well, David, you bring up a good point that I want to explore a little bit here.
You can build a good community or a good state.
David, thank you for calling in. You brought up a good point that I want to explore a little bit here, and you can explain what you call for in this Natural Defense of Marriage Act.
Yes.
In that, if you do have someone like Kim Davis, a county clerk that he was referring to in Kentucky, who says, I don't want to sign these marriage licenses, you say the Attorney General should go to bat for them and go to court for them, do whatever has to be done to defend that person.
That's correct. Now, and I will tell you, we even bring it a little bit farther, but back to David's point for just a minute, and something that Abby mentioned, and she said there's a separation of church and state. I don't find that anywhere in our Constitution. We say that, we talk about that, but my understanding of when I read the Constitution, it says government will not institute a religion. It has nowhere that religion should not be in government. It owes only a one-way street, and it clearly tells government you cannot mess with anybody's religion, but there is complete freedom for religion to do whatever that they feel that they're advocating. So I don't see where there's a separation of church and state. It's just keeping government out of that. Now, going back to your point, what my bill actually says is this, that if somebody's going to get married, and that person would go to the county clerk and they would apply for a license. And then they would take that, and that clerk would electronically transmit that to the state of Tennessee, the Vital Records Department, and they would say, does this make constitutional marriage in Tennessee? If it is between a man and a woman, they would electronically let that clerk know, yes, you can issue this license. If it does not, then that clerk would not have the authority to issue that license. So like in Kim Davis's position, they would sue her. Well, in our position, then they can't sue the clerk if the clerk does not have that authority to issue the license. So what they would end up having to do would be suing the state or whatever, and if the state is sued, then the Attorney General is supposed to defend the state. But I further went on to say, because our Attorney General, I'm not sure if they would or they wouldn't, I put in the language that the Speaker of the House or the Speaker of the Senate could hire outside counsel to do that. The funds are already there. It's already in statute for this to happen.
Abby, your thoughts on this?
The First Amendment to the Constitution requires a separation of church and state. All you have to do is read it. You can't impose the religious beliefs of one group on another, and no part of the Constitution is absolute. There reasonable restrictions can be imposed on anything, but the First Amendment clearly prevents that. And in terms of, I'm not sure if I understand what the bill is supposedly going to do about.
Let me just ask you this. Let me just take it to a personal level. As someone who's an advocate in the LGBT community, what does a bill like this do to the state of Tennessee and to the people who live in Tennessee who are homosexual?
Well, if
this passes,
it's a personal affront. It's a personal attack on people. It encourages discrimination and hostility. It minimizes a whole group of people for no reason other than a label that's put on them. I mean, there's no difference between our marriages and other marriages. I mean, I have children, to all the extent that anti-same-sex marriage proponents claim that marriage is so important for children, why isn't it important for our children too? I mean, they need all the same protection as anybody else. So I think it's an attack on a whole group of people. And the more important thing to me is that it's completely unnecessary. We have so many issues to focus on in the state and insufficient funds to deal with them. And now we have millions set aside to defend clerks who don't want to do their job. The answer to a clerk like Kim Davis is, don't have that job if you don't want to do it. It's not her she's not personally approving same-sex marriages. She's signing a marriage license as the clerk. When we file lawsuits as attorneys and we sue a state or a local official, you sue the person in their professional capacity, not as an individual. This is not about Kim Davis as a person. This is about the clerk of Roane County, Kentucky, that it's part of her job to issue marriage licenses to whoever's approved to have them, and the Supreme Court has said same-sex couples have to have them too. And if she doesn't want to do the job, she doesn't have to. Nobody's making her be clerk. But once she is clerk, she can't deprive people of their constitutional rights just because of her religious beliefs.
Okay, with that, we're going to have to take another quick break. When we come back, more calls.
Okay.
We're going to dig deeper into this, so stay right where you are.